Okay, step 2 is not going to be your favorite because we're going to talk about having to communicate. And if there's one thing we know about farmers, probably you don't want to sit around and talk about your feelings with everybody in your family, right? This is really an important step that we don't want to overlook in the estate and succession planning process. So there are kind of, I guess, two schools of thought on this. One of them I call the Uncle Fred approach, and that's because everybody has an Uncle Fred who at some time or another has said something along the lines of, I don't want to talk about this, I don't want to think about this, figure it out when I'm dead because I won't care. Sound familiar to anyone? Yeah, I don't recommend that approach, right? The reasoning is we looked at those statistics earlier. The odds of a family farm making it from one generation to the next are not good to start with. If we do that without any sort of discussion or plan or thoughtful analysis, we're just setting ourselves up to fail. And so what I really recommend is having the kind of difficult, important conversations with your family surrounding the entire estate and succession planning process. And I spoke last week with a facilitator who kind of does this for a living. She goes around and will go into these family meetings and kind of help guide them. And she told me one of the things she thinks it's important for people to realize is it takes a lot of courage to have these conversations, right? And so it's a courageous thing to do to sit people down and start talking about these things. So I really encourage you that this is not like a, mamby-pamby talk about our feelings. Like, this is a courageous thing to do to set your heirs up for success. All right, and so as far as the talk goes, at least at some point in the process, you need to talk to all of the stakeholders. And so that's going to be any potential heirs that you have, whether those may be your kids or if they may be your nieces and nephews, or maybe you've got somebody who's working for you that you're thinking about leaving things to. We need to have conversations with these people. It may be that we all need to sit down in a room and do this together. It may be that we need to sort of have multiple small conversations with each individual group that leads into a bigger conversation, right? There's no cookie cutter way to do it, but you have to talk about it. And so what do you need to talk about? Well, one of the things that I think is really important is to try and determine the interest, the values, and the goals of the potential heirs, right? And what is their willingness or desire to participate in the ongoing business operation? I'll tell you that a lot of times you may not know what those answers are until you talk to them, right? So for example, you may not know if your kids want to come back to the farm. You may not know if your kids' spouses are willing to come back to the farm, right? There's one family that I know where they had 2 kids. They both went to college. One of them moved back home to farm with the dad. The other one got a job in a town a couple of hours away. And when the parents passed away, they left all of the land to the on-farm kid and left some retirement money to the off-farm kid, thinking that they knew what those kids wanted. What they didn't know is that kid who was working in town, that kid's only dream was to go home eventually, right back to the family farm. They didn't know because they didn't ask. And had they asked, maybe they still would have done the exact same thing, but maybe they wouldn't have. And at least they could have had those conversations with that child to where they didn't feel like they were just completely left out in the dark and no one ever thought about their desires or their feelings. Another thing to think about is when is the best time to have this conversation? Christmas dinner may not be ideal, right? And I know that that's everybody's home, it's cold, nobody's planting anything, we're all inside. I would probably say let's not ruin Christmas dinner, all right? So think about when you're gonna have it. The other thing I would tell you is I think, at least for most families, it's probably not gonna be one sit-down powwow when we knock this out in an hour, right? For our own family, I'll tell you, we've been talking about this for a couple of years. And it just pops up from every now and again. Well, how are we going to split this or that? Or who's going to take this place or that place? Or, well, what if we did it like this? No, that won't work because X, Y, Z, right? It may be an ongoing thing, but I will tell you, once the ball gets rolling on that, those conversations become easier and everybody gets more comfortable with having them and kind of sharing their thoughts. So that can be a benefit as well. Another thing you could consider, and I mentioned earlier, you can think about, especially if you've got something that's pretty contentious or pretty complicated, you could consider bringing someone in from the outside to help. And that could be kind of a family communication specialist or a facilitator, a mediator, just somebody to kind of help these conversations along. Again, especially if you've got something that's pretty contentious, that may be kind of an upfront cost that would be worth investing in. So as you're looking at the communication, I think a really important piece of this is you need to identify what your main goal is with your plan. And frankly, when you walk into an attorney's office to do an estate or succession plan, that should be one of the first questions they ask you. Because the answer to that question is going to drive how we put the plan in place. And I'll give you some examples of that kind of as we go along. So you need to think to yourself, what is my main goal with my estate plan? I'm just going to give you some examples of common goals I will have people share with me. We want to keep the land in the family, right? So basically, we don't care about anything else, and maybe it's not that you don't care about anything else, but above all, we want to draft a plan that keeps that land in the family. Maybe your goal is to divide everything equally among the kids. And I have seen that where the parents have basically said, look, we don't want to think about anything else. This will be split 50-50, period. Everybody gets treated the same. That may be a major goal or value. Maybe you want to make sure the land stays in farming. Doesn't necessarily have to be your kids farming it, but somebody farming it. Maybe you want to keep the greedy daughter-in-law's hands off the place. That's a goal I've heard once or twice. Maybe you want to make sure that at the end of the transition plan, your two kids are still speaking to each other. That's a big one. Mamas especially seem to care a lot about that goal. You may want to figure out how you equitably or fairly do this plan to treat two kids fairly. That's not, in maybe doing so equally wouldn't achieve that goal. Back to our song, right? Maybe what's right or what's equal isn't fair. And that may be something that you need to really think through and have that be a goal. Maybe your goal is you don't want to lose everything you've worked so hard for to Uncle Sam by way of taxes. Maybe your goal is you want to make sure mom and dad are going to qualify for Medicaid, so you need to get stuff out of their name, right? And I'm telling you, depending on which one of these is your goal, your estate plan could look vastly different, all right? Because what works for one would be a disaster for another goal, and that's why you've really got to think through what's the most important. Here are a few things that you need to think about, and we're going to go into more detail on a lot of these. The first one is just kind of big picture. What are we going to do with the farm? Are we going to leave it to family members, right? And then if so, we got to figure out who and how. Is there this equitable versus equal issue? We need to look into that. Do we want to leave it to a non-family member? Maybe there's somebody who you think will be better to leave it to than a relative. That pops up sometimes. Are we going to sell it? Right? Is the best option that we sell this place and that would be better than, leaving it to somebody. You've got to work through what are we going to do with the farm. Another major issue that you need to think about, and we'll talk about more in just a second, is long-term care. What are we going to do for that retired generation, right? And I put that in air quotes because I don't know many farmers who actually ever retire, right? But especially if we're bringing in the next generation, we want to make sure that that senior generation is taken care of. How are they going to have a place to live? Are we going to be able to afford long-term care if that's needed? How, right? You want to think through that. Are there tax issues? And that's going to be estate, gift, or capital gains tax liabilities that we need to be aware of. Should we transfer our assets now while we're still alive? Or should we wait and let those transfer at death? All of these are considerations you need to make as you're thinking about your goals and having these conversations with your family and potential heirs. So let's talk about a few of these. One thing you're almost necessarily going to have to do is evaluate the financial status of the business. Because if we're being honest, before we can decide the wisdom or ability to bring more people into the operation, we better sort of know how we're performing on a balance sheet now, right? So we need to realistically look at the financial status. That's going to be, all those things our extension economists talk to you about. Can we cover our operating debt this year? We need to look at our net worth and our collateral. We may need to look at things like debt to asset ratios. We need to analyze our liquidity, right? That was a major issue in the song. If we need to pay cash for something, do we have cash somewhere, right? And that one can be a real problem for people because let me just give you an example. Let's say that you needed to pay, cash to put grandma in a nursing home, and you're a farm family and we don't have cash in the bank. Where's our asset value? In the land. And what has grandma told you since you were 2 years old? We never sell the land, right? So that's a situation where you better look at that liquidity and see what options you may have if that's necessary. What's the potential of the farm to support the retired generation and the generations that may be coming in to take over? If you look at the statistics as far as the average kind of withdrawal from the family farm for a kid who's working there, it costs a lot of money to support a family when you factor in if you're giving them a house and a vehicle and gas and insurance and some sort of salary. Pretty quickly you can be in the $75,000 to $80,000 range, and your farm may not have that kind of money laying around at the end of every year, right? The potential to support 2 or more heirs, that just kind of becomes compounded as you have more and more heirs that you're looking at bringing in. So that's what you really need to think about. Another issue there that comes up is if you're going to leave it, can you afford to leave it to people together? And by that, what I really mean is, can those 2 kids kind of work together, right? If they are co-owners, is this something that will be successful or not? A lot of the times we're way more optimistic about how that's going to work than it actually plays out, right? But another consideration is if you split it, right? If you draw a red line in half and one brother gets this part and one brother gets that part, did you just make it impossible for both of them to succeed because now neither one of them is big enough to make it? Again, just things you have to really think about. Let's talk a little bit about long-term care. Like I said earlier, this is a major issue as we're looking at, my parents' generation getting older. What's going to happen if we need home health to come in? What's going to happen if we need to have somebody in an assisted living home or in a nursing home? What are our options? The first thing you need to think about here is long-term care insurance. If you talk to any sort of elder law attorney, they will tell you that when somebody walks in and says, we have long-term care insurance, they're flipping cartwheels, because that's one of the simplest ways to open up your options as far as what we're going to do to pay for long-term care. As with anything else, like life insurance or anything like that, it's going to be cheaper to buy that now, right? And I know it's hard to swallow when you're 35 thinking we're paying for long-term care insurance for when I'm 70. It's something you ought to at least consider and look into. Another thing to look at is there any benefits that they may qualify for at the VA? So if you've got somebody who's a veteran or married to a veteran, there may be some kind of long-term care benefits available through the VA. Absolutely look there and kind of exhaust those options before you start trying to figure out how you can pay for it out of pocket or out of your assets. Another question to ask is can the patient afford to pay for long-term care, right? So if I think about somebody who maybe had an off-farm job, right? Maybe they worked in town and they farmed and they have a retirement account built up. Maybe that retirement account lets them afford to private pay if they need to for that type of long-term care. So that may be an option. For a lot of people who are strictly on the farm, that may not be an option, right? Because we're not very good at having good retirement plans that we are investing in, year out, if we're farming. But something to think about and at least, again, evaluate. Medicaid may also be an option, and you're going to need to sort of decide, is Medicaid something that we qualify for, we could potentially qualify for, and what might we need to do to make sure that that is an available option? On this, let me just tell you, this is complicated stuff, and you need to contact an elder law attorney to help you. The worst thing that you can do is get on Google or go to the coffee shop and start freaking out and selling assets or deeding property over because that's what you think is the right thing, and then find out either that didn't help you, but you didn't have to do it, or that it actually hurt you, what you did. So before you do anything trying to make sure someone qualifies for Medicaid, please talk to an elder law attorney who does that kind of work. All right, so as far as Medicaid goes, right, that's going to be a need-based program that you may qualify for, and you can qualify for it kind of at any age. What we're talking about here, specifically dealing with long-term care like nursing homes or home health, there are like 41 different options of Medicaid plans, and so they all have different details, especially as we're looking at qualifications for income and your assets. So there's sort of three things there to look at. The first one is what's your income and what's your assets when you're looking at qualifications. Again, those are detailed enough and there's enough options. I can't give you the magic numbers. Visit with an attorney about that. But do know there are certain assets when they're looking at, because the asset limit is low on a lot of them, like $2,000. And you're going to think, well, nobody qualifies for that, right? There are a number of assets you may have that are what they call non-countable. So that's going to be things like your residence, one automobile, assets used in a business like the farm ranch may be non-countable assets. Even certain retirement accounts may be non-countable. So again, before you freak out and start getting things out of your name, go make sure you know what you need to move on that qualification. So there's this income and asset qualification that you have to consider. Another thing to think about is what's called the Medicaid transfer penalty. This, you'll also hear people sometimes call this the 5-year look back. That's what they're talking about. What that is if you go in today to apply for Medicaid, to put grandma in the nursing home or to have home health come out to the house, they're going to ask you, have you transferred any assets for less than fair market value in the last 5 years? If the answer is yes, right? So if you gave the farm away to your son, or if you sold, this place to your grandson for $10 an acre, you're going to have to report that. And if the answer is yes, you may be subject to the Medicaid transfer penalty, which says you can't qualify for Medicaid for a certain period of time because you've made these transfers. And so there may be a time period you kind of got to wait out to qualify. So that's going to tell us a couple things. The most important one is you need to act before it's an emergency if you're going to try to start transferring property out of someone's name. Okay? Don't wait until grandma has to go into the nursing home and then try to be transferring stuff out. That's probably not what you want to do. Okay? And there are other alternative transfers that we can talk about in a minute that would be an option here. But in general, the sooner you can plan, the better, because there is that 5-year window. The other thing you want to think about when you're talking about Medicaid is called a Medicaid Estate Recovery Program. And what that is if somebody goes in the nursing home, they qualify for Medicaid, there may be assets in the probate estate that Medicaid tries to kind of come after once they die. In other words, Medicaid basically says, look, we just paid all these hundreds of thousands of dollars for you in the nursing home. We need paid back. All right? And so you need to think about what assets may or may not be subject to that Medicaid estate recovery program. And again, there are things you can do, potential transfers, different types of deeds. There are some exemptions, but where you need to work with an elder law attorney. All right. One thing I will say on this front, I did a podcast episode on my show that's called Ag Law in the Field is the name of my podcast. There's an episode we did specifically on elder law with an attorney named Kristen Porter. I think that's a really useful episode for people. If you want to get kind of into more in-depth in the weeds on these issues, that'd be a great place to start. It's free too, so that's good. But I really can't undersell the importance of having a good elder attorney who understands these really complex Medicaid issues. Next up, let's talk about the estate tax. This is something that I think a lot of people have a lot of concern about. And there is some kind of misinformation, or at least old information that's out there. So the estate tax is a federal level tax that gets imposed on assets that you are transferring upon someone's death. So when someone dies, there's going to be assets transferred. There's the potential for estate tax liability. So the way the estate tax works is there's going to be an exemption amount, and if your estate is worth less than the exemption, you don't owe the tax. If you're over the exemption, that's where the tax liability would come into play. Now, this used to be a much bigger deal because in the early 2000s, the exemption amount was about $1 million. And as you can imagine, it doesn't take very much for a farm family to get to $1 million worth of assets when you look at the value of a tractor or a combine or the land, right? So that was a really big deal, and there were a lot of estate planning steps that were taken then to try and protect farms from the estate tax. Today, at least for now, it's a little bit less of an issue because that exemption amount for 2020 is $11.58 million. So much higher exemption amount that we're looking at now. So for a single person, if your estate value is worth less than $11.58 million, you do not owe the estate tax. Right? So for a couple, that's going to be about $23 million. So unfortunately, for most of us, that's not an issue. However, okay, if you're close to that number, it's a big issue for you, and the reason is the tax you owe on the amount you're over the exemption is 40%. That's 40, right? So that's a lot of money, and it's going to be due 9 months after the person's death in cash. Again, where that liquidity issue we keep talking about could really come into play, right? So when you're calculating the value of your taxable estate, it's based on the current market value of your assets. So I don't care if you bought the farm ground for, $50 an acre back in the 30s. If it's worth $2,000 an acre now, that's what it's going to be valued at for your estate. There are a few kind of deductions you can take or non-countable figures. One of those is any mortgages or debts. So you can deduct those from your estate value. Any estate administration expenses and any property given to charities don't count toward your taxable estate. The other thing you want to know is the tax does not apply if there's property left to the surviving spouse. So the way that would work, right? If I pass away and I leave everything to my husband, I do not pay the estate tax from spouse to spouse. The kicker there, though, is now when my husband dies, he's got the entire value in his name, and now, right, the estate may be worth a lot more because it's one person. So where it could be trouble then is where the surviving spouse leaves it to the next generation. There is something I want you to be aware of that's called portability. And what that does is it essentially lets the second spouse keep and use the leftover part of the first spouse's exemption. Let me explain. If I pass away and I don't use my estate tax exemption, right? I leave everything to my husband. That means I have $11 million left that I didn't use. I could file what's called a Form 706 with the IRS, and that $11 million could be used by my husband. And now instead of having $11 million, he's got $22 million because he can use both exemptions. And that can be a really important issue to keep in mind because frankly, we don't know what things look like later, right? And think about, the price of land in the Corn Belt 20 years ago. People may be wishing they had filed portability because all of a sudden their farm's worth way more than it used to be because that price of land went up so much. So keep that in mind as well. The other thing I'll say on the estate tax is this is as permanent as Congress. So for now, the way the rule is written, it's $11 million. They adjust it for inflation. So right now it's 11.58. It'll change slightly each year. That $11 million exemption is in place through 2026. In 2026, it's going to change back to $5 million a person. So we're going to cut it in half in 2026. So beware of that, okay? And do keep in mind, a new Congress could come in and completely change it up at any time, right? So if we get a new Congress in January, they could go and say, we're going to do away with the estate tax. We don't have it anymore. That could happen. They could also come back in and say, we're going to go back to that $1 million exemption, and then every ag lawyer that knows how to do a trust is going to be rich, right? So you kind of have to pay attention to that, look for any changes. organizations like the corn producers are going to obviously keep you up to date on that, but just be aware that that is a major issue. So that's my spiel on the estate tax. Okay, let's look now at the gift tax, which these two kind of can be related, so hang with me. This can be a little bit confusing. What the gift tax is a federal level tax, again, okay, federal level, a tax on the transfer of property from one person to another if they receive less than full value in return. Right? So if I'm going to transfer my farm, you hear this sometimes, I'm going to leave the farm to my kids, I'm going to transfer it today, and the farm's worth $1 million. Okay? I would owe a tax on that transfer if I just gave it to them because it's worth less than fair market value. All right? The annual exclusion for the gift tax right now is $15,000. So what that means is any person could leave up to $15,000, gift that or assets worth that, to another person each year without accruing any gift tax exposure. So if I decide I'm going to leave $15,000 worth of equipment to my son every year until I die, no problem, no gift tax implication. Okay? If I go over that $15,000, that's where there could be a potential gift tax liability. All right? If you go over that exclusion, so if you're gifting more than $15,000 to someone in a year, you've got to file a gift tax return. That's just a form you're going to file with your taxes. But this is where it can get a little bit confusing. If you go over, you don't actually pay the tax. What they do is they deduct the amount of the overage from your lifetime exemption, which is that $11.58 million we talked about for the estate tax. So unless you're gifting more than $11.58 million, you're not actually going to shell out any money for the tax. What you could do, though, is decrease your level of exemption that you have for estate tax purposes. So let's use the hypothetical that we decide, Dad decides I need to gift the farm to my kids to get it out of my name for Medicaid purposes, right? And he's thinking ahead. He should have more than 5 years. We decide that's a good plan. Dad, let's gift that farm to the kids. And let's say the farm costs $5 million, right? That's going to be more than $15,000 in that year. So the gift tax would come into play, but Dad's not going to pay the tax on the overage. They're going to deduct what the tax would be from his $11 million exemption. Okay, so that's how the two are tied together. And so I think the takeaway here really is before you make any gifts, talk to your accountant. Make sure that you're not going to mess up something having to do with estate taxes by gifting something while you're still living. So that's just something to keep in mind on the gift tax. Like I say, the actual tax you don't pay until you've gone over that $11 million exemption. So if you wipe that out, then you would owe the tax. And the tax rates depend on kind of the bracket that you're in. They range anywhere from 18% to 40% on the tax rate. So that's gift tax. The last tax we're going to talk about is capital gains taxes. So capital gains tax comes into play if a person owns an asset that has appreciated in value over time and then they sell it. All right? There are some exclusions to this. Usually your home can potentially be excluded from capital gains taxes if you've lived there for, I think it's 2 of the past 5 years before the sale. So there may be an exemption for your home, okay? But for ag, where we see this a lot is with land, obviously, right? So let's say that you came in and, back in the 50s, you bought land for $100 an acre. Today it's worth $2,000 an acre and you're ready to sell it. You're going to owe a capital gains tax because that asset you owned appreciated in value over time. The tax rates range from 0% to 20% for long-term assets. So that's going to be anything you've held for more than a year. For short-term assets, so if you held them for less than a year, it's going to be the tax rate that corresponds with your tax bracket. So whatever tax bracket you're in, that would be your rate. There could be an option to use a 1031 exchange. again, you need to talk to your accountant, but essentially what that lets you do is if you're selling a piece of property, if you in short order are going to be purchasing another like-kind piece of property, you may be able to use a 1031 exchange and avoid paying capital gains taxes. So that may be an option. For agriculture, a major issue here has to do with the step up in basis. And so I want to talk us through kind of how that works. Let's go back to our example and say that Grandpa bought land that cost $100 an acre when he purchased it, and now it's worth $2,000 an acre, right? Capital gains taxes won't be an issue unless that land's going to be sold. So if you're somebody and that land's not selling, you don't need to worry about capital gains taxes. But if you're going to sell that asset, then you're going to pay the capital gains tax, right, and whatever the tax rate is, somewhere between 0 and 20%, on the increase in value. So from $2,000 to $100, that's going to be $1,900 that you're going to pay the capital gain tax on per acre. Okay? There is something called a step up in basis that will actually change kind of the cost basis of that land if certain things happen. So for example, one way you can get a step up in basis is if land is passed through a will. So let's say Grandpa bought it for $100. When Grandpa died, it was worth $1,000 an acre, and he left it to Dad in the will. Dad's going to get that step up in basis to the 1,000. That's the new cost basis. We don't care about the 100 anymore. Now it's 1,000, and if it's worth 2,000 when we sell it, we're paying capital gains taxes on 1,000 instead of 1,900. All right? So that can be a really big deal, and making sure you get that step up in basis may be something you want to really think about when you're figuring out your estate plan. Because if you gift that asset while you're living, you don't get a step up in basis. Okay? So again, may not be an issue if there's not a chance that that land will be sold, but if there is a chance that land may need to be sold, not gifting it during your lifetime and waiting and passing it through your will may be really beneficial because of the taxes you can avoid. So again, this may not apply to everyone's operation, but it's something you at least want to be aware of. And I would really recommend visiting with an accountant about the potential tax implications, whether that's estate taxes, gift taxes, or capital gains taxes. Okay, next up, let's talk about when you should transfer assets. Should that be done before death or at death? And I'm going to typical lawyer answer you and tell you that it really depends on your situation, right? And again, when we're looking at our goals, we're looking at having some of these conversations, that all is going to instruct how and when you want to transfer your property. So let's talk about transferring property before death. There can be some benefits to doing that. When we look at the pros of that, first one is it's just one less thing to worry about, right? We've got the transfer done, it's in somebody else's name, that's over, we can move on. Another thing is that the older generation may be able to watch the younger generation take over and operate. And there can be some, I think, real enjoyment in that, like seeing the kids that you've raised take over and see that they're going to be able to take care of the operation. I think there's some real benefit there. There can also be reduced expenses for the person who makes the transfer, right? They're not having to pay property taxes and liability insurance and those sort of costs associated with owning property. If the asset's already been transferred, there would be no probate process required for that land, right? So if the land's not in the person's name when they die, that's not part of their probate estate, right? It's already been passed. So if we're looking at ways to avoid probate, that could be an option. Another one is the land is out of the transferor's name, okay? And that, again, like we talked about before, that may be important for qualifying for Medicaid as far as the value of your assets. And if it's not in your name, if it's done timely and correctly, then it wouldn't be part of the potential assets that Medicaid estate recovery program might come back after. So all of those are kind of pros as for why you might want to go ahead and do the transfer. One other thing I would mention is once that land is out of your name, it's not part of your taxable estate, right? So when we look at the value of our estate for estate tax purposes, if that's already gone, then it wouldn't be part of that estate. There's some downsides too that you want to be aware of if you're thinking about transferring property before death. One of those is once you do that, it's irrevocable, right? If I deed the farm over to my son and let him get started and then I decide he's an idiot, I can't take it back because I already deeded it over. So you want to be aware of that. The landowner doesn't have control anymore. So again, we may not like what they're doing. We may not like how they're doing it. We don't have control over that asset because it's not in our name. The land could be subject to creditors or judgments of the heir. So, right, if I transfer the land to my son and he has creditors coming after him or he's getting liens placed on his property, etc., my property is now subject to that because it's not mine anymore. It's his property now. So that may be another concern. We talked about this earlier. There could be potential gift tax implications if you're gifting the farm prior to your death. And remember that not only affects your gift tax, but it may also affect your estate tax liability because it would decrease that lifetime exemption amount you would be eligible for. Another issue that we just spoke about is that there is no step up in basis as far as capital gains go if you transfer property before death. So that may be another downside as well. The last one has to do with Medicaid again. There are potential Medicaid implications under that Medicaid transfer penalty if that transfer is done within a 5-year time window of the person needing to qualify for Medicaid. So again, there's no, you should do this, you shouldn't do that, everyone should, transfer at a certain time. There's just no one size fits all. It really does depend on the situation, it depends on your goals, and it depends on what you're trying to accomplish. All right, I do want to talk about two sort of alternative transfer methods that I think are really interesting and can be really beneficial to get transfers to occur, but to avoid some of the downsides of a full transfer before death. The first thing that we'll mention is called a transfer on death deed. Here in Texas, at least, this is a fairly new statute. It was passed within the last few years by the Texas legislature. Essentially, what it is it's a deed that transfers the interest in real property to another person effective at the transferor's death. So if you've heard of a transfer on death bank account, right, I think we all are familiar with those, where when I die, it automatically transfers to whoever. This is the same thing, except it lets you do it for land. So you write up a deed that essentially says, upon my death, this land automatically transfers to my son, for example. So transfer on death deed, those have to be executed and filed in the county clerk records before your death. So this is one concern I think that people had when this statute was passed was, man, if people are going to be drafting these, number one, we hope they draft them correctly, and number two, they have to file them. Because if you don't get it filed and it's signed in your desk drawer, that's not going to be effective, okay? So it would be drafted up just like kind of any other deed. The statute describes what you have to include, and there's lots of, I's to dot and T's to cross in that statute. But you'd file that in the deed records. The transfer technically doesn't take place until you die, but you still have to file it and have it on file, all right? This has to be signed by the person transferring the property. It cannot be executed by a power of attorney. That probably seems like, well, that's a strange thing to require. I'll tell you where that comes up, though. If you've got a situation like we talked about before, we need property out of someone's name so they can qualify for Medicaid, and that person's incapacitated. You may need their power of attorney to be able to execute the deed, right, to get that out of their name. Transfer on death deed, that's not an option. Okay, power of attorney cannot execute that deed. The transferor retains all rights to the property. So what that essentially means is the transferor can do whatever they want on the land. It's still theirs, okay? And that transfer on death deed is always revocable. In fact, even if it says this is irrevocable, the courts say it's still revocable. That's what the statute says. So if I do a transfer on death deed, I have all the rights. I decide what we farm. I decide who farms it. I decide do we lease or not. I decide do we put up wind turbines. And then if I decide, you know what, I'm not leaving it to you anymore. You've made me angry. I can revoke it and no harm, no foul. I can either leave it to somebody else in my will. I could execute another transfer on death deed. Whatever options would still be available to me. Since the transfer doesn't technically occur until death, this offers you some benefits. The first one is that you get a step up in basis on the property. So remember I told you if you transfer it while you're alive, there's no step up in basis? Technically, this one doesn't transfer till death, so you get the step up in basis. So that can be really useful, again, especially with land, like we talked about. The execution of this deed is not a taxable event for gift tax purposes. Because again, we're not actually giving it to you now. You get it when we die, so no gift tax is at issue. Another huge benefit, and this is kind of why these deeds were created, is it does not trigger the Medicaid estate transfer penalty. So if you execute a transfer on death deed, we talked about that 5-year look back, and if you transferred property you couldn't qualify for Medicaid, this is not considered a transfer. So you could do this the day before mom goes into the nursing home and it doesn't affect her qualifying for Medicaid from that transfer perspective. It also gets this property outside of your probate estate, and then it is not recoverable for the Medicaid estate recovery program. So as a Medicaid planning tool, this transfer on death deed and the ladybird deed we're going to talk about next, very useful because it allows you to get assets out of someone's name without harming them from the Medicaid qualification standpoint. Okay, that's the transfer on death deed. The second alternative is going to be similar. It's called a ladybird deed. Now, the transfer on death deed is all statutory. So there was a statute passed within the last couple of sessions at the Texas legislature. You can go look it up. That lists all the requirements, how it all works. A ladybird deed has been around for a long time, but it's not statutory. It's sort of just something that developed, that people have used, courts have recognized, but there's no statute that authorizes it. Okay? A ladybird deed you'll also hear called an enhanced life estate deed. So essentially what this is going to do is it's going to retain an interest, a life estate interest for the person who owns the property. Okay? They're going to keep a life estate and they're going to transfer the remainder to what's called remainderment. Okay? So it will be just like you've heard people that will have a life estate, right? So maybe grandma says, I'm going to keep a life estate in this land and leave the remainder to my children. What a life estate means is she has the right to be there while she's alive. When she dies, that's gone, and it goes automatically to the remainderment. Okay? That's a life estate deed. A ladybird deed's called an enhanced life estate deed because it has enhanced rights in favor of the person who's granting it. Specifically, that person still retains all the control over the property. She can lease it, she can sell it, she can grant easements on it, she can do any of these things that normally a life estate holder would have to get consent to do. A ladybird deed lets her keep all of that control, and in fact, it's also revocable. So she could take it back and say, never mind, right? No more deed. She keeps all the powers under this enhanced life estate deed. All right? One difference here between the transfer on death deed and the ladybird deed that may matter is a power of attorney can execute the ladybird deed. And again, where you can see that the example that this plays out all the time, it makes perfect sense. Grandma needs to go into the nursing home tomorrow. To qualify for Medicaid, we've got to get the farm out of her name. We can't just gift it because then we got the transfer penalty. Grandma's incapacitated, so she can't sign a transfer on death deed. Grandma's power of attorney can execute a ladybird deed. It's now out of her name. She qualifies for Medicaid because of the assets. There's no transfer penalty, and it's not subject to Medicaid estate recovery. All right, so again, you get all of these benefits, but the power of attorney can execute. Similar to the transfer on death deed, this has to be filed, recorded in the deed records before the person dies. Similar thing here, property is not subject to the creditors of the remainderman. And I mean, frankly, the reason for that is, let's say that, grandson's creditors start poking around. All grandma has to do is revoke the ladybird deed, and now it's not a problem. The property does receive a step up in basis. All right, so that you get the step up in basis because for whatever reason they don't consider this a transfer until the person's death. It's not a taxable event for gift taxes. We already talked about this protects you from the Medicaid issues that we mentioned before. All right, the one downside to a ladybird deed and why you might want to use a transfer on death deed instead in this specific scenario is there's some concern, at least among legal scholars, that executing a ladybird deed could trigger a due on sale clause in a mortgage. And it's just because of how that is set up that they may say, for example, if you've got a mortgage and you sell the property, automatically the mortgage can be due under that. The payment could be due under the mortgage. This could potentially transfer that. It's at least something to visit with your attorney about, maybe your lender, and that may be a reason to use the transfer on death deed over the ladybird deed if there's a loan on the property and that's a concern.